in the amount of $1,713.16. Is that true or not true? Good morning. Are you April Smith?
Yes.
And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today, or the detectives asked them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment, with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am. Or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19-33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes.
April Smith is back in court, not for a new trial, but because the state believes she violated the terms of her supervision. But look closer. The prosecution is already signaling hesitation. 2 of the most serious allegations aren't even being pursued for now. Instead, everything hinges on what she admits today and what the court decides to do with it. The question is no longer just what happened, but how much it will cost her.
Alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court-assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because.
The only reason I did that is because we had the agreement.
Oh,
the new
Not
cases.
just fine.
Okay, so there is an
Right,
agreement,
right.
actually.
There was actually.
Thank you, Mr. Lewis.
And Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
And asked them to file them, and they still haven't.
Okay.
I did yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
No, Judge.
The court confirms that there is an agreement, one that significantly reshapes the risk. In exchange for the state holding back on pursuing additional charges, Smith is entering pleas of true to specific violations. Legally, that matters. A plea of true in a probation revocation hearing is enough on its own to justify revocation. That means the judge now has full discretion, including the option to impose up to 2 years in state jail.
I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
Thanks.
All right, sir, are you Mark Phillips?
Yes, ma'am.
Mr. Phillips, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Phillips, in clause number 21-36585, I have a motion to revoke your community supervision. Shows that you were placed on probation September 13th of 2021 for the third-degree felony offense of unlawful possession of a firearm by a felon. And that was a 10-year term in prison that was probated for 5 years. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of assault family violence in Orange County on October 3rd of 2025. And is that true or not true? Count 2 alleges that you provided a urine sample August 13th, September 10th, and October 13th of 2025 that tested positive for marijuana. Is that true or not true?
True.
Count 3 alleges that you admitted to your Orange County probation officer that you used marijuana on or about August 27th of 2025. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample November 6th of 2025 that tested positive for marijuana. And is that true or not true?
True.
Count 5 alleges that you admitted to the use of alcohol on August 27th of 2025 to your probation officer. Is that true or not true?
True.
And then count 6 alleges that you failed to prove the attendance of AANA meetings as directed by the substance abuse evaluation. Is that true or not true?
True.
So did you enter your pleas of true to counts 2, 3, 4, 5, and 6 freely and voluntarily? And because those counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 2 through 6 freely and voluntarily, find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing, get the probation department to do an updated report that'll give me more information about what's been going on, maybe get some more information about that count 1, the assault case, if the state intends to bring any evidence with regard to that. Well, I would think an 11 o'clock hearing would be enough.
Should be true.
Okay, so we'll set it at 11 o'clock for a hearing on sentencing. All right, go back with the bailiff.
Again.
Oh, sir, she needs your fingerprint, please.
This hearing shows how quickly probation can shift from an opportunity into a serious legal consequence, especially when tied to a prior felony. Mr. Phillips was originally convicted of unlawful possession of a firearm by a felon, a third-degree felony carrying a potential 10-year prison sentence. Instead of serving that time immediately, he was granted 5 years of probation, a structured alternative that allowed him to remain in the community under strict conditions. According to the motion presented in court, multiple violations occurred during that probation period. These included repeated positive drug tests for marijuana, admissions of substance use, alcohol consumption despite restrictions, and failure to attend required recovery meetings. Each violation on its own represents a breach of the court's conditions. Taken together, they establish a pattern of non-compliance that significantly weakens any argument for continued supervision. A more serious allegation was also introduced, an assault-related charge involving family violence. However, at this stage of the hearing, that allegation was not the deciding factor. Instead, the case turned on what Phillips admitted himself by entering pleas of true to multiple counts. By doing so, he removed the need for the state to prove those violations. From a legal standpoint, that is critical. Probation can be revoked based on a single confirmed violation, and here there were several. The judge's ruling reflects that standard. The court found sufficient evidence to revoke probation, meaning Phillips is no longer under the protection of that original agreement. The case now moves into the sentencing phase, where the judge will determine the appropriate consequence, potentially up to the full 10-year sentence that was originally suspended. If you found this breakdown valuable, don't forget to like, share your perspective in the comments, and subscribe for more real courtroom analysis.